her innermost thoughts to or anything of that nature as far as what her testimony was during the deposition about their relationship. As far as the testimony itself goes and the relevance, this is not a situation unlike the case law that the state has provided, where the state is affirmatively trying to introduce this evidence through filing a notice under the Williams Rule requirements. This is a situation where we've encountered this testimony and the defense is seeking to eliminate it out and for the court to make a determination before trial so that it's not something that we're just objecting to during the trial posture. The majority, if not all, of the cases that the state has cited are ones where the state has made an affirmative effort to introduce testimony as Williams Rule, which is contradictory to Mr. Utagawa stating that this is not evidence of a prior bad act and it's not Williams Rule type evidence. The testimony itself is really limited to just that statement. Ms. Patchen was across the street. There was no indication that the drink was vodka or alcohol of any nature. This is a situation where several individuals were never even aware that Ms. Schenecker had entered the Winmore rehab facility. Even some of her close friends were not aware of certain things that were going on in her home, and I don't believe that Ms. Patchen was someone who was made aware, other than just her absence from the home, that she would have been in any type of rehab facility. The testimony itself, as far as the cases go that the state provided, the Brown v. State, once again that being Williams Rule testimony, is a little bit different, as I pointed out to the court earlier, in the sense of we're not here in a situation where this is a domestic violence type situation where it's a girlfriend or a spouse stating that the other individual made direct threats or direct acts towards that individual. This is something where it's a third party. There's no evidence that Calix had ever made any statement that her mom threatened to kill her or, had made any efforts to kill her, in that, that is something that's being sought to be introduced. When you're talking about the Brown case, it's something where the victim was able to testify over the defense objection that she and the defendant had a rocky relationship and there were problems with jealousy and he didn't want anyone else to be in the house, which is different than what we have. And that case cites King versus State, and the evidence in that is that the defendant had severely beaten the victim 23 days before the killing, and that was proper evidence of premeditation.
Right. King is part of the materials submitted by the state as well.
Correct. And it also cites the Goldstein case, which was also provided by the state, I believe, that testimony that the defendant's wife had obtained an order restraining defendant from bothering, threatening, or harming her was relevant to the issue of premeditation. And it also cites the Goldstein... I'm sorry, Judge, that was the higher case, Hyer v. State. And then the Goldstein case, which was a prior act of aggressive conduct and accompanying threats were admissible as relevant to issue of intent. In this case, the defense is an insanity defense. The other testimony that will be produced during the trial is the testimony from Parker Schenecker, who is the individual that will know the most about the strained relationship between Ms. Schenecker and her daughter, Calix, the efforts about boarding school and what went into that, what Calix's desires were for that, what her behavior was at home, and things that were being addressed, as well as the relationship with Ms. Schenecker. These other cases involving the Williams Rule evidence are not the same as what the state is seeking to introduce in this what case. Her behavior was at home. And I will draw the court's attention to the Billy v. State case, which the state provided. In that case, once again, it was a situation where the state was seeking to introduce Williams Rule evidence, and the majority of it, and what caused the reversal was the improper admission of Williams Rule evidence. And in that case, it was a situation where the children were in the back of the vehicle and the defendant drove the vehicle into the water, and the defense theory in that case was mistake. And the only item that was deemed admissible was one that rebutted the defense theory in that case of mistake. This is, we're in a different scenario. We're not arguing any type of mistake in this case. And in regards to Ms. Patchen's testimony, there's not a lot of case law that deals with this type of testimony that is not specifically Williams Rule, which the state is not alleging that it is Williams Rule. The reason for citing the case that I did, Green v. State, is because Green v. State also goes into and cites the other cases, Denmark v. State, 927 Southern 2nd, 1079. That's a second DCA case from 2006, and that case cites Steverson v. State, 695 Southern 2nd, 687, and that's a Florida Supreme Court case from 1997 talking about relevant testimony and measuring it up to the 90.403 standards, stating that even relevant evidence should be excluded when the relevance is substantially outweighed by the danger of confusion or unfair prejudice. The threats and the prior acts that are admissible in these other cases, which the state has cited to you, are very different than the statement that is alleged to have been made to Ms. Patchen and the admissibility of that. That is a statement that Ms. Patchen herself even took as normal frustration by a parent of a teenage daughter who just made an offhanded comment. Now, the threats and the actions in these other cases that have been deemed to be admissible are not the same as this statement. Those are threats to kill that were followed by actions, or they were actions, prior violent incidences, in the cases that were cited by the state. The court has to conduct the weighing process and consider the need for the evidence, the tendency of the evidence to suggest to the jury an improper basis for resolving the matter, and the chain of inference necessary to establish the material facts. In this case, I would argue that because of the statement itself, the discrepancies in the statement, because it was not a statement that was made directly to Ms. Schenecker or was followed by any kind of incident or threat of violence at that point, and because it's a situation where Ms. Patchen deemed it to be just something made by any type of parent that would be frustrated with their child at that point or their child's behavior, I don't believe that it should be admitted in this case. The only basis for its admissibility would be propensity to commit the crime, and so we are asking for the court to exclude the statement.
Briefly, counsel.
Judge, the Torres case deals with the fact that Ms. Patchen didn't take the threat seriously, and it found that the statement was admissible in Torres. The other thing is that it shows the escalation and the difficulties between the victim and the defendant. It goes into the difficulties of the relationship between the defendant and the victim. It would corroborate Parker Schenecker's testimony that there were difficulties between the defendant and the victim. Many of the cases I cite to are statements to third parties. And also because Mr. Schenecker is in the residence, it is a familial situation. It is corroboration that the difficulties between the victim and the defendant are basically oozing out of the residence and are starting to become more serious, and it will show that it becomes more serious as time progresses, that it is serious enough that the defendant has to leave the residence, is so angry, and makes the threat that she could kill her daughter. And regardless of whether Ms. Patchen believed it or not at the time, it is relevant, and it is something that the jury should be able to consider as to the relationship and as to the motive as to why the defendant killed.
Okay, thank you. Anything else from either council?
No, Your Honor.
No, Your Honor.
All right, appreciate Council's very detailed presentation of your positions, all the case law and reading material. The court is going to find as follows. First, this is the evidence that the defense seeks to exclude by this motion in limine regarding testimony of Deanne Patchen. First, court will find that it is relevant and probative. The state has made the case that it is relative and probative on the issues of premeditation, motive, and intent and the relationship between the defendant and the victim. This is not propensity. Rather, the relevance and the probative value relates to those matters as laid out by the state. The court will find this is not Williams' rule. This is not a prior bad act. So this is not a Williams' rule issue. At the same time, the court will specifically find that this is, as the cases lay out and made clear that have been presented here today, this is not matters that are so remote as to dissipate that relevance and probative value. It's not cumulative. The state has made that case, and I'll address that more in a sense in a second. And finally, the court will specifically find, having considered argument of counsel today and all matters presented, that the probative value is not outweighed by any prejudicial effect alleged by the defense. The court sees no danger in confusing the jury with this evidence. It seems that the defense objections appear in the view of the court to go more to weight and not admissibility. Accordingly, I'm going to deny the defense motion in limine to exclude Deanne Patchen's testimony. I will do that, make special note, I will do that without prejudice to the defense to raise this objection should evidence as it comes out offer additional facts or basis for the court's reconsideration. So that'll be a simple order in this case. I've made the findings of record denying this, noting that it's without prejudice for the defense to raise that if appropriate as we proceed. Okay? Next matter.
That's all the motions we have for today, Judge.
That's all, Judge.
Now, do we have other need for other hearing dates that we can identify at this juncture prior to our pretrial?
There will be other motion hearing dates, but none that we can identify at this specific juncture. We are, just so the court's aware, we've started Mr. Schenecker's deposition. We're continuing it next week, and we're starting to depose the state's doctors.
So as far as our case management order, you're on track?
We believe so, Judge. Yes.
Yes.
Okay.
For the most part.
Once again, I promised you the hearing time you need, and as soon as you can identify that, you get together, you contact the judicial assistant, and we'll make that time available.
Okay. Thank you, Judge.
Thank you, Judge.
We're adjourned.
Yeah, just send me a message. We'll go through that.
Yeah, it wasn't much about it.
Okay. All right.
I don't know if you want that. I guess the law is I gave you my notes on.
Oh, is that with the note? I didn't look at that. That's with the note.
That's some of the stuff that they copy, photocopies of things, and then they, I just took.
Oh, thank you.